Hello, and welcome to Due Process. Today I'm joined by law professor and lawyer Craig E. Jones, QC. Craig and I will be discussing topics related to legal persuasion, bias and heuristics, and legal decision making. Craig holds a law degree from the University of British Columbia and a master's degree in law from Harvard. Craig's legal experience is extensive and has seen him appear in all levels of court, including the British Columbia Court of Appeal and the Supreme Court of Canada. He's been involved in several high-profile cases, including defending against constitutional challenges to BC's Tobacco Damages and Healthcare Cost Recovery Act, which ultimately culminated in a landmark win at the Supreme Court of Canada. Craig has also served as supervising counsel of the Constitutional and Administrative Law Group in the BC Ministry of Justice, appearing as lead counsel in cases like the Polygamy Reference, the Election Act Challenge, and the Missing Women Commission of Inquiry. Craig continues to practice law and is also a law professor at Thompson Rivers University Faculty of Law, where he teaches constitutional law and courses in advanced advocacy. Craig is also an active writer, authoring several books and numerous academic articles, one of which we'll be discussing today, titled The Troubling New Science of Legal Persuasion, Heuristics and Biases in Judicial Decision Making. Craig, thank you so much for joining us today.
Thanks for having me, Trevor. Happy to be here.
So, Craig, the main focus of our conversation today is to look at judicial decision-making and the unconscious factors that may influence decision-making and the ethics around this issue. And we'll use your article to help guide our discussion today. But I wanted to start with how you became interested in maybe looking at the psychology of persuasion and decision-making. You're a litigator and a skilled orator. So is this an area that you've always been interested in or something you've discovered throughout your practice of law?
I think in my first decade or so of practice, I was always looking for explanations of why people won and why people lost. And I wasn't all that convinced that the answers to those questions lie in the judge's decisions. I became increasingly convinced that there were other factors at play and that simply studying previous decisions isn't a terribly predictive exercise. And, that came as a bit of a shock to me. But when I mentioned this to more senior counsel, they often just sort of rolled their eyes and say, well, duh. But round about 10 years ago, this decision or this article came down that gained a lot of notoriety. And that was the study that they did of the Israeli parole courts. And what they found was a main predictive factor in whether you get parole or not in the Israeli system turned out to be the time of day that you come before the court. And even more specifically, the amount of time between the judge's last meal and when you come before the court. And that created quite a stir, I think, and it got a lot of people, including me, interested in this idea of subconscious influences on judicial decisions. And, we came to it in law about 30 years after psychology began to study it seriously. And probably, almost immediately after the psychologists started categorizing these biases, they were exploited by the advertising industry, which you would expect, because they want to influence our decisions about what to buy. And then soon after that, the politicians caught on that these subconscious biases were a lot more powerful than logical persuasion in the effort to get people to vote your way. But I think lawyers and legal academics have always been wedded to the idea that, we feel a little bit precious about it, that we're somehow above that fray and that logic rules supreme. And I think we're better at it than a lot of other areas of life. But in the last 10 years, certainly in the last 20, there's been a lot of research showing the extent to which subconscious processes, and most of them I refer to as heuristics, create biases in judicial decision making. And it's not just biases. When we talk about biases, we tend to think of racial prejudice or gender stereotyping, that sort of thing. Those certainly are a species of biases. But there's also all kinds of other odd little mental quirks that lead us to make one decision or another. And the one that we studied out at Thompson Rivers after the article that we're talking about here, but we looked at judges' preferences for even numbers over odd numbers and numbers that are multiples of 5 over other numbers. And we found, for instance, that you're about twice as likely, if you are convicted of second-degree murder in Canada, to get an even-numbered sentence as opposed to an odd-numbered sentence, right? And there is no logical, rational, or legal reason for that artifact. All it is a representation of the subconscious biases that we have in favor of even numbers. It's not just the judge's biases, right? Because these numbers are being pitched by both defense counsel and by the prosecution. So I think we as lawyers ignore this stuff to our peril. And I think the most successful lawyers are the ones that are able to exploit these subconscious processes in their client's favor. And that leads, of course, to the ultimate question of whether that's a good thing or a bad thing.
Right. Your title of the article, the one that we're talking about today, is The Troubling New Science of Legal Persuasion. Why do you think that this science might be troubling for the justice system?
Well, I think the Western justice system, the Anglo-Canadian justice system, however you want to put it, is built upon attempts to minimize the effects of subrational processes and to give primacy to the objective application of rules to facts. And it's been very successful at doing that. I mean, I think as good or better than any system in the world. What we're coming to understand now, though, is that what used to be fairly crude attempts to introduce or to bias decision makers in an irrational way, the potential now with all kinds of scientific breakthroughs in psychology, in neuroscience, in artificial intelligence, all of these things open the can of worms that persuasion and the manipulation that it involves is going to be applied much more rigorously and scientifically and precisely than it was ever able to be applied in the past. And, that's a concern. If you want each adjudication to be fair, you need to have a handle on those things and, to the extent possible, I think, minimize their influence.
And the way that ethics codes are set up for lawyers, do you think those codes are designed to account for some of the new science that has come into light?
Well, I don't think so. I mean, in the British Columbia, I think it's in the Code of Professional Ethics, they say that it's unethical to attempt to influence a court using anything but open persuasion. And, so what is covert persuasion in those circumstances? Well, clearly you can't go to the judge behind the other party's back and offer him money to make a decision. That's trite. But can you manipulate, for instance, through emphasizing, I'll use my example earlier, even numbers over odd numbers? Can you manipulate the time of day at which decisions are made? Can you use any of these other demonstrated heuristic processes? And I think we have to say there comes a point where it does become unethical, but there's been absolutely no exploration of this, as far as I'm aware, in ethics decisions anywhere in Anglo-American Canadian world.
You mentioned the can of worms earlier, and there's this proposition in Western justice systems, I guess, that we have to assume that judges and juries are making rational, objective decisions. And then if we open this can of worms of looking at some of the persuasive techniques, that we could be then opening trials to examining every single word that someone uses, or maybe looking at the evidence or images that they've used, and this will affect judicial economy and lengthen trials, etc. Do you think that is some of the concern around maybe why our justice system hasn't been as responsive to this evidence?
Well, I honestly think I found that judges have been very responsive and are very interested in improving their own adjudication. I've lectured groups of judges, the Superior Court judges in Saskatchewan last year, and this year the Civil Resolution Tribunal. The chair invited me to speak about these things. So I think the judges are very interested in improving the way they do things, and I think it's possible that even simply an awareness of these things can help. But there's also ways. We know that you're most susceptible to heuristics and biases when you're forced to make a lot of decisions more or less automatically, quickly, one after the other, and that sort of thing. So simply managing or adjusting judges' workloads are a way of, reducing at least some of these effects. Some of them, unfortunately, seem very robust. Now, I think personally, if I can put my futurist hat on, that this decade we're really going to see a lot of adjudication being turned over to artificial intelligence, because artificial intelligence can do it much better than human beings can and with much more bias. But that's up against another human bias, which is a preference to defer to decisions of authoritative members of society. So we have a natural inclination to prefer human judges, well-trained human judges. So I think eventually we're going to come to a system where most of the biases can be wrinkled out through a partnership between artificial intelligence and the wise older member of the community to whom we naturally defer.
Yeah, that's a fascinating question. I heard recently that electric car companies or self-driving car companies, for example, they rely on these algorithms and computer programs, and they essentially said that they'll have to be almost perfect before they can get people to use them, because people have a preference to wanting to have that control, and before people will switch over, you need to almost have a perfect algorithm in place, because people just have that preference to default to the human side of things. So it's interesting.
Yeah, I think that's right. And I mean, we have to understand too that algorithms are biased as well, right? That we introduce biases in the way they're programmed, what they look for, and we've seen how that can inure to the detriment of racial minorities and women in hiring and that sort of stuff. The difference, though, with artificial intelligence is we can find these biases and we can just program them out. With human beings, they're much more stubborn.
So, Greg, your article was it was a great article. It was really fascinating and did such a great job of summarizing all this the science. I just want to start with, because you do this in the article, you go through decision making, and I want to start there. Are we as rational and deliberative in our decision making as we like to think we are?
Well, the short answer is no, 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 and no. What's really changed since, well, particularly since the advent of functional magnetic resonance imaging and the explosion in neuroscience, what's really changed in that period is we always knew that there were subconscious processes and conscious processes. What we didn't understand is that at least 90% of our decisions, even quite complex decisions, are made subconsciously before the conscious mind becomes aware of them. And in that paradigm, the conscious mind is really, some people call it like a monkey riding an elephant. And the extent to which the conscious mind can then exercise control over the subconscious decisions is really what's in debate now. But I don't think any serious neuroscientist or even a psychologist familiar with the field would argue with the proposition that what we consider decisions made by us, as in our conscious rational mind, are somewhere between 0 and 10% of the decisions we make. And some psychologists seriously argue that it's zero, that we make no decisions in our rational brain, that our rational brain is really there to explain and communicate the decisions that our system one or primitive brain has already made, which is frightening.
And I've heard that our more rational brain is kind of it creates the story for why we maybe made a certain decision.
Yeah, well, I mean, a lot of people at the cutting edge of this think that consciousness and our rational mind and communication, verbal communication, evolved in harmony. That really all that does is serve the purpose of permitting us to cooperate in societies, which we do to an extent that orders of magnitude beyond which any other species has been capable of, including even our very closest relative, the chimpanzee and bonobo and gorilla. So, I mean, I guess the question from an advocate's point of view for me was, is it really just a question of learning all these subconscious processes, like some sort of puppet master and pulling the strings? Or is there something left for rational persuasion, for rational decision making? And I think there is. But it was a difficult process coming to that. Sorry, that's a very convoluted answer, but
No, that's all right. And you've mentioned system one and system two, primitive brain, rational brain. Can you just explain for our listeners what is meant by system one, system two brain processes?
yeah, well, I guess at its crudest level, you can think of system one as making sort of automatic decisions. You know, if your hand gets close to a flame, it pulls back, and there's no conscious interference in that. And you can think of all of the decisions that your neurological system makes in a day. You know, which foot to put forward and how far and how to angle your foot when it comes down, all those things we're happy to turn over to the subconscious. And the conscious brain, we think, just says walk from point A to point B, and the rest is done subconsciously. But what we're learning really is that the decision about whether to walk from point A to point B is actually primarily a subconscious decision as well. And the idea that the rational brain system two is, I think one psychologist called it the excuse maker in chief, that really explains it. They've done these experiments with split brain patients, and these are patients that have had the hemispheres surgically separated. And without going in detail, it allows experimenters to communicate with the subconscious in a way that the conscious doesn't hear it, as it were. And so they would ask these people, these split brain patients, to get up and leave the room. And the person would get up and leave the room. And then after a period of time, they'd come back in and they'd say, "Why did you get up and leave the room?" And the rational brain, then engaged, would say, "Oh, I felt thirsty. I wanted to get a Coke from the machine in the hallway." Absolute fantasy, right? But to them, it's the absolute truth. And that sort of thing has a lot of ramifications and everything from our personal lives. Anyone who's ever had the experience of asking their friends why they broke up as a couple and hearing the markedly different stories on both sides, right? And judges are all familiar with this as well. Our grasp on reality, even our own reality, is very tenuous. And from the point of view of someone studying law, that's really important because we rely entirely on judges' reflections and explanations of why they came to the decisions, right? In order to design how we're going to argue the next case. Well, what if we can't? What if the judges themselves don't understand, or at least don't fully understand, why they came to the decisions that they did? Then the whole idea of predicting outcomes on the basis of the jurisprudence for advocates is in peril.
And it's been a few years since you wrote this article, Craig. You indicated that judges do seem interested in learning about the new science and the science around persuasion and subconscious. Have you seen this being more embraced by the lawyers and legal community as well?
Oh, there's no question. I mean, there are entire corporations in the United States that have popped up built around training lawyers to exploit subconscious processes. Now, of course, they're very heavily reliant on the jury system down there. And I think a lot of people think jurors are much more easily influenced towards biases than judges are. And I think that's true. They are more influenced that way, but it's certainly not that judges, I mean, it's been shown now in experiments that judges certainly aren't immune from these things. So I've had a lot of interest from practitioners who've read the article and others like it and have said, this is exactly right. This is what I've discovered through 20 years of practice and what I teach to my junior lawyers. And now, there's a bit more methodical framework to it. But, going right back to the Greek rhetoricians in 5th century BC, they recognized that there were really three main types of persuasion, or proofs as they called them. There was ethos, pathos, and logos. And logos is logic. Logos is what they teach us in law school. And the Greeks thought that's about a third of it. And the rest is the credibility that the advocate brings to the forum, and that's ethos, the personal characteristics of the advocate. And then there's pathos, which is the emotional appeal. And when I say emotion, I don't mean, pounding the table and sobbing and all of that kind of stuff, but just the idea of appealing to subrational inclinations. Things like affinity biases, where we tend to consider people who are more like us to be more truthful. Those kinds of things the Greeks recognized as being very relevant. But we sort of lost that, I think, in the last 100 years. We persuaded ourselves that it was all about logos. And now we're coming around at the urging of the neuroscientists to appreciate a lot of it isn't. And that's threatening to a lot of people's view of the legal system.
Why do you think that is, though? Why do you think there is some reluctance, or people feel threatened by the science?
Well, I think I think that's why the Israeli study shook people up so badly. They have this elaborate system written into law where judges are supposed to be considering the probability of reoffense, the seriousness of the crime, all of these factors. And at the end of the day, the most influential factor was how recently the judges had eaten. Now that's a very peculiar data set. But it's the same thing when we went and looked at the influence of even numbers over odd numbers in sentences. I think we've pretty much demonstrated that we have people sitting in jail for an extra year because of a human inclination towards even numbers. And we have people who got out a year earlier than they should have based on those same considerations. Now, the question is really what we want to do with that information. But from my point of view, when I criticize the jurisprudence as being misleading, the reaction is, well, then you're throwing the whole rule of law out the window. And I don't think we lose that at all, because we get the rules as they're stated in the cases by which we're supposed to lead our lives. And that's the same whether those rules were decided through accurate or inaccurate adjudication. What the accuracy of the adjudication really means is that individuals going before the court might not be getting as fair shake as they should based on the facts and the law as it's derived from the previous cases or through legislation. And so that's really what I'm interested in improving, the idea of the particular justice in the individual cases.
And I imagine education is key around helping to improve this or bringing awareness around some of this science. You teach at a law school, Craig. Is this something that is taught to law students? Because I know from my experience, I went to school out east, but there wasn't a ton of information on persuasion or the psychology around it.
Yeah, well, this is one of the reasons I wanted to teach the advanced advocacy course, to sort of challenge the way advocacy had been taught previously, which was really a fairly functional, here's how you practice cross-examining, here's how you use the rules of evidence, or how you structure your argument. But I thought that there is so much more opportunity to sort of revisit things fundamentally and say, what does it mean to persuade somebody? What does it mean to move them from their starting position to your starting position? And so all of the concepts that we've been talking about really are the foundational concepts that I teach in advanced advocacy. I think there are some profs at other schools that are very interested in this stuff. The extent to which it's making its way into the curriculum, I'm not sure. I mean, we have enough challenge just teaching the logos part of it, right? And increasingly, the law schools are being burdened with teaching sort of shovel ready skills so that lawyers get out there knowing how to draft a notice of civil claim or whatever, stuff that they'd never been concerned with before. Well, that's being offloaded into the schools. And then if we now say, well, you've got to gain some expertise in neuroscience and persuasion and that kind of stuff, I can see why it hasn't really taken. But the firms that are interested in winning, litigation firms particularly, I'll call them habitual firms with habitual clients, like plaintiffs, personal injury firms, insurance defense firms. Those that have a sort of large portfolio of similar type of claims are very interested in working these ideas into the approaches they take in litigation.
Right. And there's likely to be some listeners of this interview, Craig, that will say, yeah, we hire a lawyer, or somebody hires a lawyer to leave no stone unturned and to do everything in their power to secure a successful outcome for their client. Philosophers have been talking about the ethics around rhetoric, et cetera, for a long time. So why shouldn't we want our lawyers to use every tool in their toolkit to get a successful outcome?
Exactly. And let me say, the way I usually answer that question is with a bit of a story, which is actually a heuristic device using a story instead of statistics. But I have a friend, a very senior lawyer in town here, who had a client, and the client was involved in basically a one-punch bar fight where he was a bit of a hockey hero. He got into this scrap outside a bar, one punch, and the other fellow had $23,000 worth of dental damage or whatever. So pretty serious. And the guy was convicted and awaiting sentencing. And I asked my friend, I said, if you knew that by using certain words and expressions, like if you found out that the judge, putting it in very simple terms, was a hockey fan or might have played hockey, and if you knew that by using expressions like, we've got to stick handle this case carefully, judge, we got to play for where the puck's going to be, not for where it was. If by doing those sorts of things you could build affinity with the court and improve the prospects for your client without the judge being in the least aware of what you were doing, would you do it? And he said, and I think quite reasonably, not only would I feel like I could, I'd feel like I had to, right? I feel like I'm obligated to use every legal persuasive tool in the arsenal. And I thought, okay, that's fair enough in the criminal context, right? It's you against the state, you're the underdog. But we'll put that then in the civil setting. Someone's going to pay for that $23,000. It's going to be the puncher or the punchee. If the puncher knows these techniques and the punchee doesn't, should the case be decided on that basis? Should the victim then have to pay the $23,000 because the advocate was more skilled at subconscious persuasion? And maybe you say, okay, everybody's got a lawyer. That's fair because the lawyers can be notionally thought to be evenly balanced in their manipulative abilities, right? But increasingly, we're dealing with self represented litigants in our court. So, is it still fair if you have a lawyer well versed in subconscious manipulation and a victim, in this case, the punchee, maybe self represented, who's absolutely clueless, right? Is that fair? And I think at the end of the day, you kind of get to a different conclusion that maybe it's not quite so fair. And the Greeks, as you noted, I mean, they were aware of this just in the fact that although it was advocates on both sides, they said, well, look, you're always going to have better advocates in the same way that you're going to have better wrestlers or better generals or something like that. It's never fair from that point of view. But if we're careful never to pay the advocates, that was the first thing that they thought was important. And second, if we're careful to select only worthy cases, then those that we're not going to be mercenary, really, then those effects can be diminished. The difficulty we have nowadays is that we have a much greater understanding of the art of manipulation, and on the other hand, an almost unbridled mercenary approach to litigation. And so far, that hasn't led to outrage. But I think, as you start to get psychological consulting firms being brought into large litigation, and they're going to be examining the judge's background, the litigator's background. The computers will start to be used to manipulate the language in briefs to align more closely with the judge's previous decisions. All of those things are going to be subconsciously influential. And at some point, I think people are going to say, this isn't a fair system anymore when I'm going up against this.
I recently listened to an interview with Daniel Kahneman, Craig, and he was discussing one of his new books, Noise, I think it's called, and how there's a lot of external factors that influence our decision making. But he was discussing that some of the reluctance around this research is related to the fact that as humans, we seem to prefer just the simple explanation, like you mentioned earlier, about why someone made a decision or why an outcome happened. Do you think the reluctance for some people in our legal system is related to that? We like to think that maybe humans have more control over the process than our subconscious.
Yeah, I mean, I think it is very comforting to think that it's all about human agency and conscious decisions and, relatively straightforward analyses. And that may well prevail in preserving the current system, but it's not going to prevent people from seeking increasingly more sophisticated ways of manipulating it. You mentioned Daniel Kahneman, his famous book, Thinking Fast and Slow, was what got a lot of this stuff sort of out into the public consciousness. And he and Anton Tversky in the 60s and 70s really pioneered the field of heuristics and started to define and show how easily manipulated we were by anchoring numbers, for instance, is one weird phenomenon. Kahneman and Tversky would get their students in a class of 100 and they'd say, take out your social security cards and jot down the last two digits. So everyone in the room had in front of them two digits randomly generated between 00 and 99, right? And then they would start to ask these students to guess or to say what price they would pay for, let's say, a bottle of wine. They'd say, hey, it's from Bordeaux region, it's rated 96, it's red, it's wet, it's delicious. How much would you pay for it? And what they found was systematically that students who had just written down a number in the top 20th percentile would pay about twice as much for that bottle of wine as the students who had written down a number in the bottom 20th percentile. And that phenomenon, anchoring, is so much of interest to lawyers. And it's been demonstrated, proven in very sophisticated experiments in legal settings, showing that you can improve a settlement amount, for instance, by as much as 50 or 60% simply by the sequence in which numbers are introduced to the court and to the other side. So some of this stuff is almost like hocus pocus, but it really can't be ignored by litigators.
And anchoring is an example of a heuristic. And just to make sure that our listeners are on the same page here, Craig, can you just explain what a heuristic is?
Yeah, yeah. And I get asked that one a lot because sometimes I run away with myself before I realize that no, people might not have heard the expression. Heuristic is a decision making process that's referred to as sort of fast and frugal. Okay, the idea is that our mind developed a bunch of processes that took a lot less energy than conscious thinking. And they worked well enough, often enough in the primitive environment that they weren't a problem. But now, in the environment we live in now, the inclinations that we have do skew us in predictable ways. And Kahneman's whole thing was showing how that influenced the stock market. And he actually, although he's a psychologist, he won the Nobel Prize for economics because he showed that stock market actors were not rational beings as economists predicted they ought to be. But just back to the idea of what a heuristic is. So we have two thought processes, really. And you might remember the computer in 2001: A Space Odyssey, HAL 9000. Well, HAL stood for heuristic algorithmic. And the idea was that you couldn't be a complete thinker until you had both algorithmic, which is like x plus y equals z, combined with these fast and frugal heuristics swirling around, influencing the decisions. And of course, with HAL, making the computer think like a human introduced systemic processes that led to him murdering the crew of the spaceship, and in the end destroying the very mission that he was supposed to be on. But that's the idea of a heuristic. It's a measurable subconscious process that leads us to predictable biases in favor of even numbers, for instance, or making us more conservative or more liberal in our decisions if certain apparently unrelated factors are manipulated.
And you mentioned in your article, Craig, that some may argue that we expect judges who are experts in law to make quick decisions. So why is it still important to pay attention to those heuristics, though? Because of the biases that could result?
Yeah, yeah. I mean, when we read a judicial decision, it's usually the final decision in the case, and it's after 2 or 3 months of deliberation. And so we feel fairly confident that judges, have had the time to confront any potential noise, to use Kahneman's term, and to eliminate it. But the fact is, a trial process or even an appeal or judicial review, there are a whole bunch of decisions that are being made throughout that process very quickly. Is this witness credible? Should this evidence be admitted? Should an adjournment be granted? All of these things pile up and at the end of the day lead to that well considered decision. But if those decisions are influenced, I mean, people find taller people to be more truthful than shorter people. It's absurd. It has a great evolutionary explanation, but it's awful in the court process. We find you can actually make more accurate assessments of people's truthfulness when they're on the phone compared to when you see them in person, and all these other biases come into play. That's one very interesting aspect of COVID, changes to courtroom processes in COVID. We have much less information about the people that are appearing before us. And paradoxically, we may be making a lot better decisions in that environment than we would be if they were right there in front of us.
Yeah, that is a bit of a paradox. We're looking at nonverbal cues and assessing truthfulness and trying to see who's lying and telling the truth. And heard that a couple times, that there's research to support the notion that if you actually don't see the person, you might be batting at a better average in terms of telling who's being deceptive. nonverbal cues can be important for other parts of communication, for instance, about expression and if they understand what you've said to them, that sort of thing. So
Sure.
reading those behaviors is still important, but certainly some people have told me that they would like to see that removed from any assessment of credibility. For example, there's the judge will still tell a juror that they can look at someone's demeanor on the stand, for instance. And some people are concerned about that because of, as you indicated in your article, we will quickly form opinions about somebody just by seeing them for a second or two.
Yeah, well, and I think it was in Malcolm Gladwell's most recent book, he talked about judges' ability to predict reoffense in offenders being granted bail, right? And he interviewed a bunch of the judges, and the judges were all saying, "Oh, you know what? After doing this for 20 years, I can just look them in the eye. I just look them in the eye and I nail it, right?" And then so what they did was they developed a very crude program to predict the probability of reoffense based on, I don't know, like 8 very basic factors. And what they found was that this simple program was, I don't know, 2 or 3 times more accurate in actually predicting the rate of reoffense than these judges that were so proud of their ability to assess on the basis of appearance. So, I mean, one of the ways we can avoid the influence of heuristics, and again, paradoxically, is limiting the amount of information that a person receives. If you're worried about, for instance, gender bias in hiring, one thing to do is to have somebody go through the resume packages and eliminate any reference that would reveal gender. And you'll find that your hiring suddenly becomes more gender blind than it otherwise would be. So we can look at the legal system and think of ways that we might deprive some of the traditional pieces of information. I think the Civil Resolution Tribunal, which does, its adjudication essentially in a paper process, is a fascinating experiment. I mean, it would be wonderful to do a study of the accuracy of CRT decisions versus, for instance, small claims court decisions in similar cases, because CRT doesn't have the advantage of looking people in the eye and doing all that kind of stuff, but it might be making their decisions better than the alternatives.
So I want to turn now, Craig, just to getting into some of the examples you discuss with respect to heuristics in your article. You categorize them in 3 different categories. So presentation triggers, substantive triggers, and then the structural triggers. Just wondering if we could start with presentation triggers and maybe just give an example or two and work our way through the other categories. I can start with presentation triggers. Some of the ones I flagged that I found particularly fascinating was just the idea of for presentation triggers, last attorney to the jury box is a rotten egg. So the importance of going first.
Yeah, we're often taught that how important it is to have the last word, but study after study indicates that actually what's most important is the first word. And I mentioned the idea of anchoring, right? If you come out with a ridiculously highball settlement figure or damages figure, it will influence the sort of debate thereafter. And that's a very simple, straightforward example of it, because that's just numbers. But the fact is that the person going first, and a lot of litigators recognize this, they frame the narrative, they frame the story. And so the first person to get that to the jury, as it were, or get it before the judge, I think is going to be more influential. And that should factor in high profile cases with respect to media messaging, for instance, right? Because getting out front in public with your story may be a way of getting it before not just the decision makers, but potential witnesses, opposing counsel, all of those types of things. So yeah, who speaks first is more important than who speaks last, without question.
And under the presentation trigger as well, the person's appearance, which you've already touched on a bit with height, for instance. But the quote from your article is, "What is beautiful is good."
Well, and that was the bizarre thing, right? Because it's one thing to say, I'm attracted to that person, I find that person attractive. But to say subconsciously, as we do, I find that person to be more truthful, that's weird, but it's true. Unfortunately, it's a bias that we have. And it appears to be just one of these evolved things. So much of credibility, whether we choose to believe someone or not, evolved as a consequence of our alliance building inclinations, right? We have to be conscious of who we want to build alliances with. And big, powerful, attractive people are going to have an advantage in that realm. And, they've studied symmetry of features, for instance, right? Because it correlates with both beauty as it's subjectively assessed, but also with health as it's objectively assessed. So we've developed ways to ally ourselves with more healthy people. It makes perfect sense to do that. But it's one of those things that ripples through our subconscious and has these effects that we don't want them to have in a courtroom. If we applied a filter and turned everyone into a cat on Zoom, it might actually result in more accurate assessments of people's truthfulness.
Right, that's a good idea. I think that would be enjoyable as a spectator.
We'd also all get a smile out of it.
So the second category was substantive triggers, and you discuss how reminding a judge, for instance, of their mortality can actually influence their decision making.
Yeah, the mortality salience is a really weird effect, and it's one of the ones that was studied fairly early in the legal setting. We become more conservative and more in-group focused and less tolerant of diversity and divergence from social norms in circumstances where we've been reminded of our own mortality. In other words, where things are put in some sort of life and death situation. So the study, was out of Arizona. They took a bunch of judges who assessed bail amounts for a fictitious prostitute in the fact pattern that they used. And they told the judges, the great thing about psychology experiments is you often get to lie to the people that you're experimenting on. You tell them what you're going to ask them, but you don't have to tell them why. And so they said, we're going to subject you to this personality questionnaire because we want to find out whether your personality correlates with the amount of bail that you award in this situation. But to half of the judges, they added a couple of questions to the personality questionnaire, which just asked them to contemplate what they expected to be the circumstances of their own death and how they thought it would feel before, during, and after their own death. So they just asked those two extra questions. But when they did, it increased, I think it was 5 or 7 times the bail amount that those judges would impose on the prostitutes. Completely, on the same prostitute. Completely beside all of the legal and other characteristics, because those were all identical. The only thing that changed was that these judges were thinking about death. And when they were thinking about death, you didn't want to be appearing before them as a prostitute. And of course, they used a prostitute because that was, especially in Arizona 20 years ago, 30 years ago, that had sort of moral overtones and in-group, out-group overtones. So yeah, that kind of thing is just weird. The idea that you can introduce the substantive elements of into your argument that will skew the outcome or the probability of the outcome in a predictable way. And I think that's probably of all of the different fields, that's probably the one that is most in need of further explanation, I think.
Yeah, I'm sure as we study these things more and more, we'll find more of these same triggers. I read recently about appearing in front of a judge on a Monday, and if the judge's football team was successful on Sunday, really indicated in terms of sentencing, the type of sentencing that would be delivered. So if the judge's team won, they would give more lenient sentences than if their team had lost, which is interesting and concerning.
Yes, agreed on both counts. Yeah.
But no, it's fascinating, these different triggers. And
Well, and the weather has also been shown to be influential, right?
yeah. And the other one I found fascinating under the substantive triggers, Craig, was their normality and omission biases. So if a lawyer can frame their client's behavior as normal, a judge or jury has a bias for normality. So if the Crown or something, and you want to try to get an accused, you want to frame their behavior as abnormal and unusual.
Yeah, that's right. And outside the sort of accepted social activities. One experiment that was done just asked people to assess somebody's liability for a car accident at an intersection. And it was a young man. He was involved when he went through a stop sign without completely stopping. And there was a collision. So the question was the extent of his liability. And in one of the conditions, in one of the scenarios, he was rushing home because he realized that he'd left his parents' anniversary gift on the dining room table, and he had to hide it away before it got home. And in the other condition, he was rushing home because he realized he'd left his drug paraphernalia on the dining room table, and he had to put it away before his parents got home. And to nobody's surprise, the adjudicators were treated him much more harshly if he was rushing home over the drugs compared to if he was rushing home to do a nice thing for his parents, even though it was legally irrelevant. So that's an example, I guess, of surrounding circumstances that shouldn't be legally relevant, but that as a litigator, as an advocate, you would want to take as many of those opportunities to put the white hat on your client's head and put the black hat on the other side's head, even if they're not strictly relevant.
Okay. And the last category in your article was structural triggers. And we discussed anchoring already and how that can influence decision making. And that was the only example I kind of took from that category, because I just find anchoring very fascinating. It's that there's been a lot of research.
Yeah, well, anchoring and the sequence in which things are said in both oral and written presentations is very important. A sort of category jumping thing is the way we manipulate language. It shocks a lot of people to find out that if a phrase rhymes or has a certain rhythmic appeal, that people not only are more likely to remember the phrase, which of course is very important to an advocate, but they're also more likely to consider the phrase truthful, which is extraordinary, right? But, we all remember Johnny Cochran, if the glove don't fit, you must acquit. And we all sort of laughed about that at the time. But it's actually true that people consider rhyming passages to be more truthful. People consider things that are delivered in threes to be more truthful. And that's one thing that the Greeks understood quite profoundly in their oral advocacy. But the opportunities, I think a lot of litigators, just through trial and error and intuition, come to a lot of these rules. And a lot of the greatest legal writers never studied any of this stuff. But if you look at their briefs, you realize they're using it all. One of the things that I do in my advocacy class is I go and I look at, well, on my exam this year, I put up a 30-minute speech from Margaret Thatcher and said, go through this speech and pick out all of the advocacy techniques that she's using that we've talked about. We look at Richard Nixon's checker speech, all of these contexts outside of law, and you realize that people are doing this stuff all the time. They're just not studying it as methodically as I think they ought.
So we'll move now to considering the more philosophical and ethical questions around this, Craig. And I just want to start with the current procedural safeguards, which we touched on codes of ethics earlier in our conversation. But are there other current safeguards in our justice system that can help manage some of these persuasive techniques?
Well, as I said at the beginning, I think a lot of our justice system is built around reducing the effectiveness of subconscious persuasion. And so that's great. And I think the more aware judges are of certain things, like if a judge was acutely aware of the influence that the sequence of presentation goes, right? Our legal processes are actually very manipulative of sequence of presentation. Someone who bears the burden on a point is almost always allowed to make the first submission on that point. And that's a way of countering the burden, right? And that's just something that's evolved as an organic part of our process, but it's quite well entrenched now. And so just being aware of some of these things, deciding who gets to speak first, I think is a great first step. And I think the judiciary is very interested in improving those sorts of things. We did an experiment, there's the truthiness heuristic, which I think I talked about in that article. And that's when people see a photograph, they consider an accompanying statement to be more truthful. So they'd show a picture of a turtle and then they tell people turtles are deaf. And they found that people are about twice as likely to believe that turtles are deaf if you show a picture of the turtle. Even though the picture does not bear on the question, it relates to the turtle. And for subconscious reasons, we think that is more credible now. One of the reasons, quite possibly, why we're very jealous about media presentations in our courts, right? We're quite suspicious of, and we should be because they're more influential than they ought to be. But we did an experiment at our university where we did a repeat of that New Zealand experiment about the turtles, but we put it in a legal context. We said that the statement we said was a properly designed railway crossing would not cause a properly ridden bicycle to crash. Right? It's a fairly ambiguous statement. You could agree with it or not agree with it, whatever. And then we showed a picture of a railway crossing sign to half of the subjects. And when we asked those questions of undergraduate psychology students, the effect of the photograph was really quite profound, as it had been elsewhere. If you showed the picture of the railway crossing sign, people were completely sucked in. However, when we ran the same experiment on third-year law students, what we found was an extremely muted effect of that same heuristic. And we were then curious about whether it was legal training that was reducing the effect or whether it was the selection, that somehow the law school selection process, with the LSAT and GPA and all that stuff, whether that was just giving us a less susceptible body of research subjects. So in order to tease out that effect, the next time we ran the experiment, we did it on first year law students in the very first week of their classes. So they'd had no training, but they'd had all the selection. And what we found then was the line went right up the middle of those two things. So if that held true across the board, it's only one experiment, obviously, but if it held true across the board, the two important things about eliminating biases in the judicial system are going to be selection and training. And right now, we don't, except very, very indirectly, we don't select our judges with respect to their resistance to subconscious biases. It would be very easy to develop a test which did so, but we don't do that. And we're, I think, only at the early stages. I think the training for judges in these things is kind of ad hoc, and I think it relies overwhelmingly on the judge's own drive to improve their own judging. So I think there could be more done on both the training and the selection sides. And I can anticipate resistance in both counts, to be honest.
Because you're taking away the human element or the discretion, maybe?
Well, and I just think it's innately offensive, not just to judges, but to all of us, to be confronted with the idea that we will make irrational decisions, that we will predictably make irrational decisions if we don't guard carefully against it.
So, Craig, can you see that, putting on your futures hat again, that those who are selected to be judges, until the computers take over anyway, will have to go through a selection process where maybe this resistance to subconscious influences is a factor in whether they're appointed or not?
I'm not sure. And the reason I'm not sure is because I don't know whether we care enough about accurate adjudication. I think that we as humans, it's much more important for us just to get the matter before an authoritative, respected figure and have it decided one way or the other, and out of that system to have a bunch of rules by which we can live in the future. I think that's really what the social interest is. So yeah, it's funny because when I talk to lay people about this, they seem much less concerned than judges do. Or, lawyers obviously have a keen interest because they want to win. They want to make more money for their clients and for themselves. But the actual lay people out there, I think they sort of accept that it's a bit of a crapshoot, and if the right people win most of the time, as I think they do, then that's good enough, often enough.
Okay. So maybe there's an acceptance that it's a human system, obviously, and we're never going to be perfect.
And we prefer the humanity of the system to a flawless but inhuman system.
Okay. So one of the questions you consider in your article, Greg, is, and we've touched on and danced around a little bit, but why do legal rules, why do they still matter if we know that there's heuristics and biases influencing judicial decisions?
Yeah, and I guess I did touch on it earlier. I think we do need rules and norms and laws to live by. However, they're derived. They could be handed down at the Temple Mount. They could be derived from a social consensus through a legislature, or they could be handed down through a body of cases by judges. The most important thing is that we have a system and that it overall has socially beneficial results. So in that context, the accuracy of the adjudication in individual cases really is really is secondary. It matters only if you actually are in court before a judge, and most people won't ever be.
So I want to turn now, Greg, to just discussing more of the ethical dimension here and how we should be looking at this ethical question. But I want to start first with your thoughts on whether, and I think I already know the answer to this based on our conversation thus far, but whether lawyers are already manipulating these heuristics and biases in your opinion.
Yeah, even if they don't know it, they are, right? I mean, every lawyer who puts a witness on the stand, the witness may be, an auto mechanic or a homeless person, but they're going to go on the stand with a suit and tie or a nice outfit, nice respectable outfit on. There's no reason for doing that except to subconsciously manipulate someone's perception of their truthfulness. So we do this all the time, and we've always done it. The question is whether there's a point where it becomes less like putting on your best appearance and more like beaming a laser beam into the lizard brain of a judge and having them snap to attention like the Manchurian Candidate. Right, somewhere between those two extremes, there's a threshold, and we as litigators have to decide to what extent that happens without any accountability. Frankly, we have no. If we get it wrong, what are the consequences?
And I guess the difficulty in trying to determine where this line is, Craig, is that a lot of this is happening at the subconscious and may not even be registered and understood, right? It's difficult to look at a specific case and really determine what biases or heuristics were used. I think the data comes from looking at cases more generally and a lot of cases. So how can we do that? How can we look at trying to determine where the line should be and which persuasive techniques are too much?
You're right that we'll never really see their influence. We can gather influence from looking at cases as a whole, but really there's so many factors. In the Israeli parole study, it was easy, right? Yes, no. Do you get parole? Yes, no. Right? That's a very nice data set to work from. But if you're trying to find out what influenced civil judgments, for instance, it's a nightmare. I've tried to design studies, and how do you even determine, if you're trying to determine what's effective advocacy, who won or lost? Like if I wanted to find out in civil litigation whether female litigators were more or less successful than male litigators and whether the gender of the judge mattered in that, I'd have to have some method of determining what success means.
Mm-hmm.
And I don't, because a $500 million judgment against your client might be a pretty good outcome if otherwise it would have been $1 billion, right? And yet that would go down as a loss and that kind of stuff. So it's really hard to actually come to grips with what success means, let alone sort of what's influencing it. And so we come back to the granular level of it really being up to the individual litigators. And I think the lawyers, the advocates, are going to try to improve everything that they possibly can bring to bear on a situation, knowing that if they get caught doing it, they might get a worse outcome for their client than if they hadn't. So there's obviously self-imposed limits that are gonna come into play. You can't be obvious about any of this stuff. But for me, it all comes back to the Greeks' solution, which was you just have to be careful about which cases you take on. And obviously, as mercenary advocates, we can't be completely free of economic imperatives in that sense. But that doesn't mean that we're completely powerless either. I think in cases that we take on pro bono, or that we do, as we say, low bono, or in cases that no matter what they pay, we just won't take, I think at the end of the day, those are the principal ethical decisions that we make as lawyers, because once we're in, we're all in, right? And it's very hard to address this at the back end. We just have to decide where we're going to focus our gifts and skills, and including our subconscious techniques of persuasion.
As a lawyer and a litigator, there's going to be persuasion, and no matter what type of argument you're giving, there's going to be some level of persuasion in it.
Yeah, and persuasion is at its source extra legal, right? I mean, it's the idea that advocacy is bringing to bear something more than the facts and the law. And as long as it's that, then it's almost extra legal process. You're trying to change the outcome that would have applied had it just been the facts and the law into your client's favor, and the other side is doing it, the other way. And as long as it's that exercise, then advocacy is inherently raises the questions of ethics and equality of arms and and whatnot.
And again, it comes back to that line, where is too far, and using those persuasive techniques. And your article discusses how there's tension, I guess, of duty to the client and duty to the court. And ultimately, Craig, do you see this just kind of falling on the shoulders of individual lawyers to make that determination?
Yeah, I kind of do. I think that we have to be more aware of it, both from the point of view of improving our own techniques, but also recognizing how they're being used against us. For years, I would go up against a particular very senior and experienced counsel in Vancouver, and on more than one occasion, we'd walk into the court at the beginning, and I would be about to present my, application or whatever. And this person would say, "Oh, look, just before you do that, I just want to say a couple of words to the judge, just to sort of lay the framework for where we're at. Can I do that?" And of course, I would defer because they're a QC and all the rest of it, right? And so this person would get up and within the course of about 3 minutes would set out his first he'd say, "Mr. Jones has graciously agreed to let me just bring you up to speed procedurally." And then for 3 to 5 minutes, he would explain his entire client's case. And I wouldn't understand how persuasive that was because I didn't understand the stuff about the sequence of presentation. But he basically stole the case from underneath me in those 3 to 5 minutes.
Yeah.
And had I been aware now, if he'd said, "I just want to bring him up to speed on the procedural stuff," I would have said, "Oh, well, let me know what you want to say and I'll say it as part of my presentation." I wouldn't cede that field to in the circumstances. So you really can't, even if, you don't want to use any of this stuff, it's going to be used against you. And you owe it to your client to do what you can to make sure it doesn't bring them down.
So as a judge then, Craig, looking, you have two lawyers in front of you, is the hope that, like you said, education and awareness, you can see some of the persuasive techniques that they're using, and then from awareness, not be so prone to allowing those to affect your decision making.
Yeah, I think part of it's conscious and training, like I said. And, getting back to the point about selection, although we don't select for biases or resistance to biases, I think the push for a more representative judiciary, a more diverse judiciary, has had profound effects on a lot of the most harmful of the biases, right? And it's for a couple of reasons. First, because people who don't share sort of mainstream biases of a particular demographic of judges are making decisions. That's one of the effects. But the other effect is it's been very well demonstrated that the only effective way proven to reduce things like racial and gender bias is to improve the amount of contact that people have with members of other ethnicities or the opposite gender.
Mm.
And so just bringing together a more diverse collegiate of judges, I think, has improved a lot of those macro biases immensely. The micro biases have been a lower priority, though, and I think they largely remain.
So, Craig, as we near the end here, I don't want to abuse your time here. I just want to know if there are any specific practices or steps that you would like to see implemented in an effort to maybe minimize some of these, what would be considered improper tactics. So maybe like intentionally going, whatever that line is, intentionally trying to be manipulative in court. Is there any practices you would like to see set up?
Well, I think the judges and the Judicial Institute are increasingly engaged in the training of judges. I think to an extent it's going to be a generational thing. I tend to find that younger judges are much more enthusiastic about looking at this stuff than older judges are. So I would like to see, but I don't have any expectation of seeing some assessment of susceptibility to bias made part of the judicial screening process. But honestly, I think we really need to take a hard look at the experience of the last year in online courts and in telephone conferencing and tease what we can from that data. Look at the Civil Resolution Tribunal again. I keep coming back to that, but I'm a big enthusiast. And just see what works and what doesn't, and whether we can make our system not only more efficient, but in doing so, maybe eliminate some of these difficulties.
Maybe modernizing a little bit and keeping up with the technology that's available where you don't always have to be in person for these types of hearings.
Well, I don't think anyone would say if we landed on a Terra Nova planet right now and decided to set up a society with a legal system that it would look exactly like the legal system that's evolved over the last few hundred years, right? Because we have very, very different needs and expectations. now. But we have a court system that is deeply rooted in a starkly different era. So I'm enthusiastic that different groups are taking a fresher look, and maybe it took the disruption of COVID to have people step back and say, what's actually essential here? What are we actually trying to achieve? What's good enough, often enough, instead of perfect but infrequent?
Well, it's going to be fascinating to watch how this develops and to see how this does influence our justice system. And Craig, your article was excellent. I really enjoyed reading it. And it's an excellent article in terms of summarizing all the different science and evidence out there. And I can't thank you again enough for coming on today.
Well, thanks for saying so. Nothing I enjoy more about chatting about than these things. So thanks for indulging me.
No problem. And we will link your article in our show notes. And yeah, we'll link your profile and your articles in our show notes to this episode.
Great. Thank you very
Yeah,
much.
thanks a lot, Craig.